So going back just real quick to the PR point, because this ties into it. One of the things that you need to consider isn't just the hard costs, but what are the long-term PR costs to your company as a result of failing to maintain the security of your clients' information. If I were to find out today that whichever company it was got hacked that had my information, I'd likely switch to a different company because I want to make sure that this company is trustworthy. And we all know that mistakes happen, but at the end of the day, you have to also consider those PR hits. Whenever you're talking about the communication ladder, so most cyber insurance applications require you to have a cyber incident plan or a business interruption plan. Both of those should contain some form of a call chain that identify who and in what order you're communicating with individuals. And this is extremely important. So Lawyer 101, right now, there is a split in some of the courts about how much information during a breach is actually protected by the attorney-client privilege. As a result, to the extent maximally possible, all information and communication should occur through the higher-ups, only authorized individuals with the attorney. That's so that you can maintain that attorney-client privilege to the greatest extent possible. So we don't want low-level employees communicating with the lawyer because that may actually do away with the attorney-client privilege. The privilege only attaches to certain people within the organization itself. So that's a really important issue to understand. The other important issue for people to understand is that we never want to say the word breach. And as a lawyer, I always say the word breach. So I'm violating my own rules, but we don't want to say that until we actually know there's a breach. Because once you say the word breach, and especially if you put it in writing, you've now triggered a whole slew of legal liabilities on your end. So for example, in Oklahoma, and all 50 states, including certain federal laws like HIPAA, et cetera, have some form of a reporting requirement once a breach has occurred. And the definition of breach does change from state to state or federal regulation. And so as a result of that, you have to know whether or not something is a breach. So in Oklahoma, it's not a breach if, for example, the information was encrypted. Well, at the end of the day, perhaps those individuals could unencrypt it and it would technically be a breach. But because it was encrypted at the time it was extracted, it's not considered a breach. And that's extremely important. So for example, recently I had a client in Washington who had mailed some information that got lost in the mail. And in that information was some confidential proprietary information. So I had to figure out Washington's definition of a breach to determine what we were obligated to do. And at the end of the day, this just didn't fit into that category. So understanding the technical words and knowing what to say and not say is important. So I tell everybody, don't ever say the word breach. Let your lawyer use that term or let your higher ups use that term. Don't ever say it on your own because that's just bad news at the end of the day.